So welcome back to Evidence. We're going to now be looking at the very first topic that we'll consider as part of the reading, and that's relevance. And as I mentioned in the introductory video, relevance is something you have some working familiarity with. Does the evidence that we're offering pertain to anything that matters in this litigation? But we want to use more specific, more precise language in understanding the rules so that we're all on the same page and so that you sound like you know what you're talking about. A lot of times in the questions and answers, I'm going to use language that is not identical to the statutory language to make sure you actually understand it. But when you're talking to a judge, the closer you can hew to the actual language in the statute, the more precise you'll sound and the more credibility you'll have. So when we talk about relevance, does something matter? What is that exact language? So let's share the screen again and go and look at chart a course, and we will look at, pull this up, share. And so you should now be seeing chart a course. So we've seen the introduction already. We want to now go to relevance. And we're going to want to pull up the federal rules of evidence, 401 and 402, which are the main rules that govern relevance in criminal and civil proceedings for all courts that use the federal rules of evidence, which certainly includes Pennsylvania. They've adopted their own version of it, but much like with the UCC, Pennsylvania and every other state in the country, with the exceptions of Connecticut and California, use not only the same substance for the rules, but the same numbers for the rules. Connecticut and California will use different numbers, and there's certain differences for those two jurisdictions. But for Pennsylvania and for everybody except those two jurisdictions, understanding the federal rules of evidence will get you pretty much all the way you need to be to understand what's admissible and what's not in not just a trial, but any proceeding that uses these rules. So when we talk about relevance, it's governed by two rules, essentially, 401 and 402. 401 says that evidence is relevant if, A, it has any tendency to make a fact at issue or a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. So there's a lot packed into that. Let's kind of unpack a bit of it. When you see words like any tendency to make a fact that is of issue, or any fact more or less probable, that is about as low a standard as you could imagine the law having. So how good does it have to be? It doesn't have to be good at all. Any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Well, what does that mean? Well, that means that while your fact might, to use the kind of the classic metaphor, might make it more or less likely that the price of tea in China is higher or lower, the price of tea in China is sort of the classic metaphor for something that's not relevant. So the fact that you're making more or less likely has to be something that matters in this litigation. And then 402 says something that's fairly obvious, but it's worth observing. 402 says that relevant evidence is admissible unless any of the other provisions of either the U.S. Constitution, a federal statute, these rules, or other rules provided by the U.S. Supreme Court make the evidence inadmissible. The best example of that, for those of you who have had criminal procedure or are taking it now, the Fourth Amendment to the U.S. Constitution has been interpreted to exclude unlawfully obtained evidence, so long as, or exclude unlawfully obtained evidence, even though it would make a fact at issue more or less admissible. Of course, 402 then says irrelevant evidence is not admissible, just kind of the other side of Rule 401. So those are the rules, and in our next video, we'll begin to look at the State versus Newman case. Close this for you, and I'll come back to full screen, stop share. In our next video, we will look at our very first case, State versus Newman.